All right, so you just filed a complaint with the Division of Labor Standards Enforcement, or the Labor Commissioner, as a lot of people call it. You filed it, you submitted it, you received a notification of confirmation. Now, what happens next? Now, wage theft occurs all over the state of California, much more than people know about, but realistically, there's a lot of different ways for you to prosecute that or litigate that or actually stand up for your rights. And this video is going to talk about the DLSE, which is an administrative process the state of California has, where you can advocate for yourself and your lost wages without an attorney at no cost to you, where you don't even have to pay a filing fee. Now, there's pros and cons to this specific process, and we're going to be talking about some of them. But first things first, I'd like to introduce myself. My name is Adam Juratovac, and I'm an employment lawyer over here in San Jose, California at Juratovac Law. Standing outside right here in front of Santa Clara County Superior Court, the old courthouse, not the new one, and just got done with a case management conference. So I decided to shoot this little video and before I head back to my car, head back to the office. So, Labor Commissioner Office, right? DLSE, Department of Industrial Relations. There's a lot of misnomers for this specific agency, but it is actually the Division of Labor Standards Enforcement. So after you file that complaint, what do you expect? Well, number one, in 2025, you have to expect a delay because there are a lot of complaints in that process, especially during 2020 and the COVID times when people were filing a lot of complaints because they were learning about their rights. There's a big backlog of cases that are waiting to be heard. So one thing I tell all my clients and all the people who call our office is, if you file a complaint with the Labor Commissioner's office, you should receive a notification that you'll have what's called a claim in conference. A claim in conference. You'll receive a notice of claim in conference, or what I call a NOC, N-O-C-C, which is essentially like a pre-trial conference or a settlement conference sometimes. So when you receive that notice of claim in conference, just know that it might be a mediation, it might be a settlement discussion or a settlement talk in there, one or two talks in there, but also realistically, what's happening is you have the Deputy Labor Commissioner going over your complaint, learning about your employment to make sure that your complaint is accurately filled out and accurately filed with the correct amount of allegations, meaning, whether or not you're employed between X date and X date, and you worked how many hours of overtime that you weren't paid, or you received how many missed meal breaks and missed rest periods, just to make sure that the complaint is semi-accurate. The reason why they make the complaint semi-accurate, which sometimes the Labor Commissioner takes your claim and blows it up, right? Where you see $50,000, $100,000, $500,000 dollars that you're demanding, is because in order for due process to be fulfilled, the defendant, your employer, the defendant needs to have actual notice on what they're going to be defending. So if you file your complaint and then on the day of the trial or day of the hearing, it's a Berman hearing, the Labor Commissioner learns that you actually want to allege that you weren't paid for 5,000 overtime hours within a certain set of time, but the defendant was only prepared to defend 100 or 200 or 500 hours, then due process was not satisfied, and the Labor Commissioner is going to have to reset that hearing or limit you to how many causes of action and how many hours you could actually allege. You want to be careful of that. So the notice of claiming conference is the first step. That's the first place you got to look into. So at that notice of claiming conference, the Labor Commissioner is going to ask you for your name, who the employer is, when your date of hire was, what was your date of termination, how many hours you worked, how many rates of pay did you have, what were your rates of pay, aka how much were you paid per hour or salaried, and also how many hours were you not paid, and how many meal breaks did you miss, how many rest periods did you miss. So you have to be prepared to talk and discuss about all of those specific points, and it's your job to be credible. So don't just go into the claiming conference unprepared. You should go on to a website called like time and date calculator, so you can calculate how many work days there were between your start date and your end date, and then that way you can estimate or calculate how many days you worked, how many days you had 1 hour of unpaid overtime per day, how many days you had 2 hours of unpaid overtime, and the percentage of times that you missed your lunch period or rest periods. Now, the more information you have, the better. But at the claimant conference, that's not your opportunity to plead your case. That's not your opportunity to bring evidence to support your case. That's just the pre-trial hearing or the settlement conference, where the labor commissioner is going to clean up your complaint and make sure it's accurate. So then when you go to your trial, you go to your hearing, then that's going to be the show. That's the game day. That's when you actually have to prove everything. So after the labor commissioner is going to ask you about all those specific details, then they're going to ask you, hey, would you be interested in trying to mediate this case? And at that point, obviously say yes, because you want to hear what they have to say, what either party has to say. But at the same time, just know that when you go to a notice of a claimant conference at the labor commissioner's office and you're represented by an attorney, or they're represented by an attorney, or you're just representing yourself, 90% of the cases that go through that point do not settle. And it's for a variety of different reasons. One reason is that the defendant isn't taking the claim serious enough, so they're not offering enough money for the resolution. Another big issue is because how you have to clean up that complaint of all your allegations. Sometimes that balloons up the bottom number to be huge, completely unprovable, but huge. But at the same time, if you're a plaintiff and you're seeing that big old number, even though it's unproven, unprovable sometimes, and probably not going to end up there, the plaintiffs or the claimants sometimes anchor their settlement dollars or anchor their settlement value in that large number that the labor commissioner provides. So heads up on that, because there's this one case that I had where we were close to a resolution, and then all of a sudden the labor commissioner said, okay, you know what? I'm going to assume that this person wasn't paid for 10 hours of unpaid overtime. So where the original claim was only $15,000, it ballooned up to $200,000. And then at that point, the person definitely didn't want to settle. I was on the defense side. I was representing the employer in the situation. So then you actually have to go to a hearing, and when the person earns or receives an order, decision, or award that's far less than what your best settlement offer was, that's when they get pissed. So heads up on those big balloon numbers, because you might want to calculate that separately. Call a law firm. There's a bunch of different legal aid clinics that could help you calculate the potential damages that you're owed, or even be represented and then have that lawyer do all the calculations for you, because then you'd be able to figure out what a good settlement, what a good resolution amount is. So heads up on that. So when you go to your mediation, because a lot of the times these calls are on Zoom now, sometimes the labor commissioner doesn't let you take on your camera, put it on. Sometimes they don't let you take it off. So just be prepared for either or. A lot of the times it's off. But what they're going to do is they're going to put you in one room, they're going to put the defendant in one room, and then the labor commissioner is going to go to your side. All right, what do you demand? Plaintiffs always demand the same thing. It's like, I want the maximum amount that's listed in the complaint, the big balloon number, or in a lot of times the accurate number. And then they go to the other side, and then the labor commissioner goes to the other side and say, hey, defendant, the plaintiff wanted to settle this for this big old amount. What do you say? The defendant will say, that's a bunch of bullshit. I'll give him $100. I'll give him $1,000. I'll give him $500. And then that's when the plaintiff, so heads up on this, that's when the plaintiff will sometimes see the big number that the labor commissioner calculated, and they'll see the tiny little minuscule starting point demand that the employer offered, and they'll say, nonsense, I'm out of here. They're not taking me seriously. Don't do that. Don't be that plaintiff. Always try to be, in each stage of negotiations, always try to keep an open mind. Always try to figure out, okay, what do they think about this case? What dollar amount are they offering? And how do I counter? Because when you're looking at a settlement, when you're looking at a resolution, you're not getting 100% of what you're entitled to. You're getting somewhere in the middle, right? Because when you're in somewhere in the middle, where you're not happy that you're getting that small amount, but then they're not happy that they're giving that big amount, that usually means that there's a good resolution when both sides are unhappy. So 90% of the time, your case will not settle at the claimant conference, and then you'll be given a hearing date. Now, in the state of California right now, these hearing dates are given about 1 to 3 years in the future. So, just know that you're going to be waiting in line. You're going to be standing in a pipeline for people, and then once you get your hearing date, it'll probably be set between 1 and 5 months in the future. So make sure you clear your calendar when you get that date, because based on how big the line is, The labor commissioner is not rescheduling these hearings. They're not. So if you don't show up, they're going to create an order of decision or award. If you're the plaintiff and you don't show up, it'll be dismissed. If you're the defendant and you don't show up, you're just giving the plaintiff an open opportunity to just start taking clean shots at you because you're not there to defend yourself or provide any opposing evidence contradicting their claims. So that's why you need to show up. But when you go to the hearing, it's a Berman hearing, meaning that you have the opportunity to submit evidence. So absolutely create an evidentiary packet. You have the opportunity to subpoena witnesses. So absolutely subpoena witnesses. Now, a lot of the times the witnesses won't show up unless, you're requiring them to show up or they're compelled to show up to support you. So heads up on that. But you also need to provide the labor commissioner of all the witnesses that you plan to interview, all the evidence that you have, and then you need to send all of that list and that evidence to the other party, to the other side, because as much as we see in court movies and TV shows now, where on the day of the trial, right before closing arguments, there is a document that was found that is going to build your case up and then prove it 100%. We're not allowed to do that, because just imagine if lawyers and plaintiffs or defendants even were just hiding documents all the way to the day of trial. That's unlawful. You can't do that. So make sure you share all your evidence with the other side as well. Now, you're required to provide that evidence about 2 weeks before your hearing to both the labor commissioner's office and to the other side. Now, heads up, if you have a really big file, you have to print it out and then drop it off or send it to the labor commissioner's office in addition to sending it to them via email. A lot of the times when you're working with some of these administrative agencies in the state of California, they're still using older systems. So their email addresses aren't able to accept a certain amount of megabytes in an email attachment, even though Google allows it. So heads up on that. If you have a lot of documents, it's better for you to go print it out, drop it off at the labor commissioner's office, or print it out, mail it to the Division of Labor Standards Enforcement, to the office that you're working with a return receipt requested, so that way you can show that you actually sent it out and they received it. In addition to that, definitely send it to the labor commissioner's email, send it to the opposing party, because you want to be able to list off all of these different steps that you took in order to get your evidence submitted and admitted for the hearing. Now, when you go to the hearing, gosh, man, it's just like any other trial. Depending on the labor commissioner, they're going to start with either the defense or the plaintiff side, and then you're in the show. Prove your case. Hire an attorney if you need one. Definitely consult with a lawyer if you have the time or the funds, but even if you don't have the funds, there's a lot of agencies and a lot of groups out there that provide free or low-cost assistance to people in those situations. So, one thing is I love the legal process because it affords everyone the opportunity to represent themselves. But number two, I've been a lawyer for over 12 years, and I could tell you if I were in that labor commissioner situation, I would not want to represent myself. So I'm not necessarily saying I can't, but I think there's an old adage that says, he who represents himself has a fool as a client. And that's just something I always remembered. So if you have any other questions, drop them in the comment section. I'll see if I can answer it. And here's a reminder, I'm not your lawyer unless we sign a contract. This is not legal advice specific to any one individual, but instead just talking educationally about an administrative process that we have in the state of California. And my one bit of legal advice is you need to find a lawyer. So, all right, cool, that's it. All right, everyone. See you later.